Director, as you point out in your testimony, policing insider trading is central to the mission of ensuring confidence in the markets. And I assume that you often get anonymous tips. And anonymous tips on insider trading cases, or have things referred to you from CorpFin. And I'm wondering what other avenues you look to for information. For example, if a Federal judge raises serious questions about insider trading in a ruling, is this something that could trigger the commencement of an investigation into securities laws violations, or is an investigation, let's say there's an ongoing investigation, are issues raised in a court proceeding potential evidence for the Division of Enforcement?
We have a number of sources of information relating to insider trading cases. A prominent source is SRO referrals. FINRA and ORSA refer cases to us often. We also now have developed internally a mechanism for finding insider trading through data that we have, blue sheet data that we have. Obviously, if a court decision were to come out which suggests there's insider trading, it clearly is also something we would look at.
If a judge raised those serious questions, I see. As for what makes up insider trading, do you look to the law for guidance? Do you discuss potential investigations with your colleagues in CorpFin? I assume it's not always as easy as Justice Potter Stewart's rule that you know it when you see it.
We do obviously have dialogue internally, including with the Division of Corporation Finance, about violations of the insider trading laws.
And it's clear to me that sometimes you have to answer complicated questions in order to bring an insider trading case to the Commission. Under the Securities and Exchange Act, and specifically Rule 14E3, there are many hurdles that have to be overcome, and I was hoping you could help me understand some of those today. The first is this question of what constitutes a substantial step or steps toward a tender offer. Do you look for tactics commonly associated with a hostile bid? Say, for instance, Company A is making an offer to buy Company B. If Company A begins a PR campaign and hires financial and legal advisors and sends multiple threatening letters to Company B's Board of Directors, directly communicates with Company B's customers and employees, would this not meet the threshold of commencing a hostile tender offer?
I think it's a facts and circumstances inquiry. What a substantial step towards a tender offer is really can be a complicated question in certain cases, obviously. So I think it really depends on the facts and circumstances.
And here's a follow-up on this. What if Company A's board meeting materials clearly reflect a recognition by the board that a move to acquire Company B would most likely require a hostile takeover? Or what if Company A simply makes a self-serving statement that it is not taking a substantial step towards a tender offer? Is this enough to establish that as fact?
Again, I think it's a facts and circumstances inquiry. I'd need to really sort of examine the facts and circumstances to have a view on that.
And another question that has only recently been raised is, what is the SEC's definition of who would be considered a co-bidder or a so-called co-offering person and therefore exempt from the scope of the rule?
Again, it depends on the facts and circumstances and what kind of conduct the individual or the entity takes.
Would a person or persons brought on as a strategist or financier by Company A qualify as a co-offering person under the rule? What would have to be established for this person to qualify for the exemption from the disclose or abstain rule that applies to those with material non-public inside information? I was hopeful that the SEC can provide some clear guidance on these issues in the future, and so that's why I asked the question for the record, if I could have a response on those.
Again, it's a facts and circumstances inquiry. I'd really need to examine the facts more closely.
Thank you, Director.
Thank you.